Omulamuzi wa kkooti enswikulumu Kisakye ayawukaine ku balamuzi baine 8 bw'abaire ng'awuliriza omusango Kyagulanyi bw'akubye nti ensonga dhaibwe edisinga kwe basinziira okuloba okusaba kwa Kyagulanyi okwongera obujulizi mu musango kwali kukyamu.
Before I read, I want to note that my file has been confiscated by the Chief Justice of Uganda. I am aware that my views above differ from the ruling of the court in this application, in which I concurred and where we unanimously ruled as follows with respect to this issue. Court finds that the issue of qualifications of the first respondent in the proposed amended petition is a new matter which comes outside the limitation period for filing a presidential election petition. Therefore, we disallow it. Having critically reviewed the constitutional provisions I have cited above, I have come to the conclusion that I arrived at a wrong decision to rule as above.
Ona wakaini okusalawo kuno ng'abitambuwairo bw'anokwoireyo wala n'okwidukiza kkooti nti musango amambabazi ogw'ebyokulonda yeekirizibwa okwongera obujulizi waire ng'ebiseera ebyekirizibwa byali biweireyo.
Without referencing Article 102 of the Constitution from where it is derived, led the unfounded view held by the respondents that a successful presidential candidate's qualifications can only be challenged under Article 104 of the Constitution and Section 59(6) of the Presidential Elections Act. I hold the view that a constitutional challenge based on the lack of qualifications of an elected president, as provided for under Article 102, can be made: 1. Before the election is held; 2. During the presidential election petition filed under Article 104(1), or at any time after the 15 days have lapsed. 15 days under Article 104 have lapsed without a petition being lodged in the Supreme Court, or 4. After the conclusion of a presidential election petition.
Ku nsonga ya Kyagulanyi gye yasaba kkooti emuyikiriza okukyusa mu mpaaba, kkooti n'emulobera ono akubye nti wairenga mu kusooka yeekiriziganya ne balamuzi baine baasalawo nga Kyagulanyi yali azira mukisa guno, owabiri omukuzi guno yeekyusiiza ng'akuba nti amateeka gamuyikiriza okukyusa mu nsalaye era amaliriza ng'akuba nti baine baasalawo mu bukyamu.
While treating its own previous decisions as normally binding, depart from a previous decision when it appears to it right to do so, and all other courts shall be bound to follow the decisions of the Supreme Court on questions of law. I'm further aware that although this right is vested in this court as a whole, this article does not exclude the possibility of a single justice of this court to depart from a position he or she has taken earlier.
Onera akubye nti President Museveni wala n'ekibiina kya NRM bawangere mu buyinza okumala myaka 35 azira bakuba ku mukono, so nga Kyagulanyi n'ekibiina kye kya NUP babato mu by'obufuzi ate ibanga liba nkamalawo gavumenti eyidde ng'ebatwala nkyagi.
The reasons I find that in the interest of justice in this case favor an order that each party meets their own costs.
Wabula onayikirizaganina ne balamuzi baine ku kikolwa kya Kyagulanyi okutwalayo omusango mu kkooti kyakubye nti kino kye yali yeesigaza kyonka kubanga yalemesebwa mu ngeri nningi omuli okumuziyiza okuwaayo obujulizi obumala okukyusa mu mpaaba ye n'ebindi ebirumira kamaala byali yeekengera mu kkooti.
Other than the above, I stand by the rest of the ruling of the court rendered on 4th February 2021. In support of to withdraw the petition, Kyagulanyi
wairenga omulamuzi ono alaze omutima ogw'obuvumu yaziimoola ebiragiro bya mukama we Winyidolo kiri kulindirirwa okubona obanga ensalaye gyasomerwa n'amawulire nga baakalaani n'abakubiriza ba kkooti bazirawo bannamateeka abaagabirwa boona nga bagiire obanga enaasigala ng'ebalibwa nti ntuufu mu mateeka. Joel Kafuko n'atusakiira ewuwe lino ku lwa Baba TV Amakonde.